Scotland's criminal justice system appears to be on course for fundamental reform. MSPs at Holyrood have been debating a bill which would, if passed as is expected, make huge changes to the administration of justice in this country. Some of the key changes include removing the controversial not proven verdict, a verdict unique to Scots law. Changing the threshold for returning a verdict from a simple majority of 8 to a 2/3 majority, meaning 10 of the 15 jurors would have to be in agreement for a verdict to be reached. And the creation of a specialist sexual offences court, which would deal exclusively with the prosecution of sexual offences. With more than 160 amendments tabled to the legislation, MSPs have been engaged in a long day of debate and discussion. Before today's debate, the Justice Secretary Angela Constance outlined what the bill hopes to deliver.
I believe it's in the interests of justice and fairness that victims are supported to give their very best evidence and are not re-traumatised by the justice system. And the Criminal Justice Committee has heard time and time again that particularly for women and girls who've experienced some of the worst sexual violence, that they then go through the justice system only to be re-traumatised. Yes, the justice system must be fair to both the complainer and the accused, but fairness also requires giving victims a voice.
Well, to discuss the general principles of the bill and what it seeks to achieve, we were joined by the criminal defence advocate Edith Forrest and Ellie Wilson, a sexual abuse survivor and campaigner. Edith, the not proven verdict looks like it's on the way out. How do you feel about that?
I feel concerned about it, John. It is, it's a unique verdict in the Scottish criminal justice system, and I think it's little understood by people who are seeking to get rid of it.
And Ellie, you had not proven verdicts returned in some of the charges against your former partner, and you've openly said as a sexual assault survivor. How did you feel about that when that verdict was delivered?
It was difficult because for me personally, I actually preferred getting the not proven verdicts to getting a not guilty, because to me it felt like the jury believed me on those charges. So it felt nicer in a way, but also there's a sense of lack of closure as well, wondering, if there was a 2-verdict system, might those not provens have been guilty verdicts? And
there's been a lot of talk about this for a long time, Edith. I'm sure you've been in here more than once talking about it. You think this is likely to go through, despite the resistance of the Scottish legal establishment? I
think it is. I mean, it's popular amongst politicians, isn't it? It's going to voters, it sounds good. But for those of us working within the criminal justice system, it's not. It's a safeguard that's being removed, and I'm concerned about it not, a similar safeguard not being put in place once it's gone.
Well, let's look at some of the other broader issues that have been discussed. So we now see the potential for the threshold for returning a verdict increased to 10 jurors out of 15. Is that maybe not an adequate safeguard for getting rid of the not proven verdict?
I don't think so. I mean, only time will tell, really, whether it is or not. But I don't think so because, as I say, at the moment we have a simple majority system where out of 15 jurors, if 8 vote for guilty, that is sufficient to send someone to jail for a very long time. And that's why the not proven verdict is a safeguard in those circumstances. So I think it's been debated, they may reduce the jury number to 12, but I think they're sticking with 15 and upping the majority to 10. But in my view, that's still falls short. In England, for example, they have generally unanimous verdicts, or a judge can direct that it can go down to 10 too. So I think at the very least it really needs to be around 13, 12, 13.
And that might make convictions, Ellie, a bit harder. How would you feel about that?
Yeah, I think that the changes to the jury majority is going to make it a lot harder to secure convictions. I suppose, though, on the other hand, people might argue that that having a greater level of consensus amongst the jurors makes verdicts feel a little bit more secure. So I can understand that perspective. And I suppose it does balance out any sorts of changes that might be brought in by the removal of the not proven verdict. I do think that concerns about the impact on the accused are a bit overblown, to be honest, because ultimately the sufficiency of evidence remains the same. All that removing not proven does is bring Scotland in line with the rest of the world. In
terms of the jury number, what do you think it should be, Edith? If it's not 10 or 15, what would you, happy enough, keep it as it is, 8 out, just a simple majority? From the jury, yeah.
When the not proven is removed?
Yeah, if we're seeing the threshold changing, we're focusing the thresholds here, and you don't think that that 10's enough, would you rather just keep it as it is, the 8 out of a simple majority should be enough?
No, I think it should be a unanimous, or at the very least 12 or 13 jurors voting. So
you're happy enough that there's a change at least?
Not really. I don't think it goes far enough. But
right.
As I say, I think only time will tell as to what impact that's going to have. But no, I don't think it's enough of a safeguard.
What should we say to those that are saying that juries, it's a very expensive system as much as anything else, the number of jurors we have, and that this argument that it should have been reduced to 12, as you say, it's unlikely to go ahead. But would it be helpful to have smaller juries, do you think?
I actually haven't even thought of this, but no, I can't see that that's going to make a discernible change or difference. No, I don't. I can't see that reducing the number of jurors. I think my concern is with the the majority and how that fits with the number of people they are, whether it be 12, whether it be 15. But it seems that we're sticking with the 15 as is.
And Ella, there's talk of also specialist courts for sexual offences. Is that something you would welcome?
It's something I'm really torn on, to be honest. I support the idea in principle of specialist courts, but I think, one, we really need to maintain the solemnity of proceedings. For a lot of survivors, it's really important, that rape cases are heard in the High Court. It's the highest court in the land. It reinforces how serious the crime was. So maintaining solemnity is important. But as I understand, the plans for the specialist courts still use the existing prison estate. I don't know if there's going to be any sorts of radical changes to how these trials are conducted. I think that there was an opportunity here to try and change things in quite a fundamental way. Would we look at new court buildings that would have separate entrances for the accused and for the victim and their family? Could we look at ways in which a victim and their family could observe the rest of the court proceedings? In what ways are we actually going to make these courts more trauma informed? I just have a lot of questions there, and I worry that it won't be implemented in the proper way.
What are your thoughts on that, Edith?
My thoughts are that we currently function in a system where many of these measures are in place. So we have commission hearings regularly for people who are involved, complainers in sexual offence cases. The way that they are treated absolutely should be treated is with respect and dignity. Lawyers are not allowed to give that kind of hassle to complainers, or to be respected, and that's only right. I worry, like Ellie says, I think it's a reduction. We're going from rape cases being heard in the High Court to this specialist court, which, as I understand it, the judges overseeing proceedings may be sheriffs, people that aren't used to dealing with such serious cases. I'll also take Ellie's point. There's a dreadful system whereby complainers are bumping into accused people and vice versa. That shouldn't be happening in today's system. Whether that would require new buildings, I don't know, but that shouldn't be happening. But I think overall we have a system that works. It respects complainers. It provides for them to give their evidence in ways that they want. So I can't see it making any huge difference. And in some ways, I don't think it will serve the interests of complainers as this current system does. And
early court transcripts to be made available to survivors who go through the criminal justice system. What difference would that make?
I think it will make a huge difference. This is something that I've been really passionately campaigning on because for me, I wanted to make a complaint about the defence lawyer in my case's conduct because he was really aggressive towards me. I thought that he had violated the rules that exist within the courtroom. But to make that complaint, I needed to access my court transcript, and at the time that was going to cost me thousands of pounds. Okay. So I think that by having access to free court transcripts, it's going to enable greater transparency and accountability in court proceedings.
Ellie, Edith, thank you both for joining us today.
Thank you.
Thank you.